I'd like to welcome you before the committee, and I do want to note that I've been informed that you had brought your family, and they're very lovely, but your young son in the hallway has made a great impression on everybody he's dealt with out there. Go ahead. We're ready for your opening remarks.
Well, thank you for the opportunity to appear and answer your questions this morning. Thank you also to those who met with me during the last 2 weeks. I appreciated having the opportunity to talk with you about the process of selecting nominees and to discuss the qualities and skills you are looking for in Supreme Court justices. Before taking your questions, I will briefly review why I aspire to be a Supreme Court justice and what assets I would bring to the court. As you've seen in my application papers, and most of you have heard during our discussions, I want to serve as a justice because I have a strong interest in continuing in public service, an aspiration instilled in me by the examples of my parents and grandparents who were very involved in local community service as I grew up in rural northeast Iowa. My own community service began in a small but important way in middle school as I accompanied my grandpa in his American Legion post as I played my trumpet. I played taps for Memorial Day services. And though my long track record of public service has focused more on state and national service, my desire to serve flows from the same basic values instilled in me as a child growing up. Second, I care deeply about the proper interpretation of the law and its careful application to the facts of each case, regardless of personal views. I'm committed to seeing justice administered fairly to all parties, and it would be an honor to undertake the hard work and critical analysis necessary to reach and communicate principled decisions in complex and difficult cases. Ever since one of my Iowa State professors encouraged me to go to Harvard Law School, I haven't shied away from taking on legal challenges and doing my best on the legal issues set before me. And third, I welcome the opportunity to help the justices of the Supreme Court lead their peers in the Iowa Judicial branch through its current and future challenges. As I did in my responsibilities as U.S. Attorney, I would bring sound judgment and collegiality to the bench, and I would thrive in an environment with a mix of legal and leadership responsibilities. As for the assets I would contribute to the court if selected, my appointment would bring to the Supreme Court a unique breadth of civil and criminal legal experience, tested leadership and practical administrative skills, and a firm understanding of the necessary but limited role of the judiciary in our representative democracy. First, I believe I have the intellect and work ethic to do an excellent job critically analyzing legal issues, appropriately deciding cases, and effectively communicating those decisions to the litigants and to the public. Second, I have significant and broad criminal and civil expertise gained through many diverse experiences, such as serving as chief federal prosecutor for 52 counties in northern Iowa, helping brief and litigate complex constitutional and civil rights issues in the Civil Rights Division as a senior level Justice Department official, representing the United States in civil matters as both plaintiff and defendant, trying federal criminal cases as a line prosecutor, litigating state law civil issues in private practice in Cedar Rapids, and clerking for a federal appellate judge in Iowa. Third, I have a real-life appreciation of separation of powers issues, having worked in all three branches of the federal government and having worked in the state executive branch, in the Farm Division of the Iowa Attorney General's office, and in the state legislative branch, working for the chairman of the Judiciary Committee in the Iowa House of Representatives. As a result, I understand the institutional strengths and weaknesses and the challenges faced by the legislative, executive, and judicial branches of government. And I recognize the judiciary's own temptations to exceed its proper institutional role, as the other branches, in their own ways, sometimes exceed theirs. Fourth, I have significant leadership and administrative skills, which I regularly used and honed as United States Attorney. For example, in leading an experienced and talented 60-person office, including 26 attorneys, in the full range of its criminal, civil, and legal and administrative work, serving as the chief federal law enforcement official in northern Iowa, which involved fostering effective working relationships with federal, state, and local law enforcement, overcoming major logistical challenges after the 2008 flood, one of the largest natural disasters in U.S. history, which forced us to vacate our main office along the Cedar River in Cedar Rapids for 5 months, and overseeing an extensive and at times unprecedented caseload and finding creative solutions to meeting the demand. The best example is the Postville immigration enforcement action, where hundreds of cases, about 2/3 to 3/4 of a normal year's worth of criminal cases, were handled efficiently, professionally, and in a manner that protected the rights of the defendants. These management skills equip me in a distinct way to help pursue solutions to the current challenges faced by the Iowa judicial system, such as ensuring access to quality justice despite heavy caseloads and limited resources, and interacting effectively with the public and other branches of government. Given my rural Iowa farm background and engineering education at Iowa State, I also would bring a practical, common sense farmer-engineer approach to resolving these and future challenges. In closing, I would like to tell you a brief personal story. When my wife was expecting our first child, we were living out of state, and I was dreaming about moving back to Iowa. As we discussed baby names, I proposed Iowa for a girl's name and Justice for a boy's name. My wife was a little concerned because she knew I was only half joking. Fortunately, though, in that instance, I had the good judgment to follow my wife's advice, and we named our son Caleb instead, who, along with my wife, as you said, is here with me today. Yet I think you can still count my initial fatherly instincts as genuine evidence of my love for Iowa and my passion and enthusiasm for serving our state in the pursuit of justice. It was a high honor for me to serve half of Iowa as U.S. Attorney. If you give me the opportunity, I will eagerly accept the challenge and the responsibility that comes with serving all of Iowa as a justice on its highest court. Thank you for your consideration, and I'd be happy to entertain your questions.
Mr. Dummermuth, I want to thank you for your opening statements, and I just want to note that I wish more young people would come back to Iowa with talents like yours and help make this state a better state. But that said, are there any questions on the right side of the table? Mr. Fitzgibbons?
Good morning, Mr. Dummermuth.
Good morning.
I commend you on bringing your son. I can remember being that age and coming with my father to the Supreme Court to argue a case. I'm not going to tell you how that case came out, but we appreciate you being here very much and bringing your family. I'm interested, you have some very significant federal experience being a presidential appointee, which is a very impressive matter in and of itself. Do you see any distinction in your experience as a federal prosecutor working in the federal system with our state system? And more particularly, I'm interested in what your opinion is on where the roles of the court start and stop, whether or not the courts should be influenced by the passions and opinions of our citizens.
There are a lot of similarities, I guess, in the federal and state courts. The way a judge approaches a case should be the same. Their personal views should play no role in the decision. They should look at the law and the facts and apply them. In interpreting constitutional or statutory provisions, you look at the text, the context. And so in a lot of senses, they're the same, but there are important distinctions. There are different resources available in each system. I believe there's more advanced technology in the federal system, which plays a role in how caseloads are handled. And so there are differences as well in the types of cases. Of course, the federal courts are courts of limited jurisdiction, as opposed to the Iowa courts, which are courts of general jurisdiction. In terms of how the public, how public views, I guess, or public pressure should play a role in deciding cases. I think the public has already decided how their role should play, how they should play, and that's by the constitutional provisions they've passed and the laws they've passed. And that's what a judge should base his or her decisions on. And to any greater extent than that, public pressure shouldn't come into play.
Any other question, Ms. Dixon?
Mr. Dummermuth, if you would just speak briefly to your reading and writing in the last few years in your capacity as U.S. Attorney. I know one of your writing samples had been referenced. It's the appeal brief that was in U.S. versus Bentley, and that actually it wasn't one that you had written, but you had just edited it. But as you know, as a Supreme Court Justice, you'd be the one actually writing the materials. If you could just talk about the reading and writing and the researching that you did, especially in your last position.
Sure. Well, I looked at every word of that brief, I can assure you, before it was filed. And throughout my 3 years, I think we filed over 150 appellate briefs in federal court, and I reviewed probably 90% of those. I love those issues. I looked at them carefully. Given my responsibilities as U.S. Attorney, and the fact that I didn't try those cases at the trial level, in all cases we have the assistants that tried the cases write the initial briefs. They usually have, motions, pretrial motions already drafted, and they can do that most efficiently. But I can assure you that I looked at those briefs carefully, and I did do writing on my own, but most of that's not for public consumption, so I didn't have any examples to provide. I love to write. I love editing, and I think you can look at some of my letters of support can testify, I think, to my abilities both to research and write. The only research I did were on the most difficult and complex issues that we faced. But I first started with using the experienced attorneys in my office to get their opinions, and only if I thought there was something weak or something they didn't address would I go research it myself. But certainly when I clerked or in private practice, and when I was in the Eastern District of Virginia trying cases myself, I certainly did all that work on my own.
Thank you.
Professor Cochran?
Morning, Mr. Dummermuth. Thanks for coming this morning. You mentioned the agro-processors case that you were involved with, and that generated a lot of controversy in my part of the state, especially among some of our Latino population and among some religious communities. I guess, what did you learn in dealing with a case like that about, responding to or diffusing or dealing with public controversy around particular cases that sometimes come to the Supreme Court that you might have to deal with?
Right. I learned that it's not much fun to be under a lot of restrictions in what you can say publicly about ongoing cases, but I think that comes with the job you take. And so as a Supreme Court Justice, you're stuck in many ways with relying on your written opinions. And we were stuck with relying on the facts we presented to the court and the legal arguments we made. In terms of how we handled that, there are some things we tried to do in advance to let the public understand what we were doing that wouldn't prejudice the rights of any defendants. We took video of the facilities in Waterloo in advance, and we gave that to the media so they could see where people would be housed or what the court facilities would look like. We made ourselves available for press conferences to answer questions that we could answer. We allowed visitors, congressional delegations, the Guatemalan consul visited the site up there to observe personally what was going on. And so to the extent we could, without disrupting the law enforcement operation going on, we opened things up to the not to the public, but at least to some members outside of what was going on. And I think as a Supreme Court justice, to the extent you can make things open and accessible, I think that helps, but there are certainly limitations that have to be respected.
Any other questions on this side? Let's start with Mr. Holm.
Thank you. Thank you, Justice Wiggins. Good morning, Mr. Dummermuth. Thanks for coming today. When we spoke and when I had a chance to look over your written application, you obviously had a good deal of experience working in the Civil Rights Division of the Department of Justice. Tell us a little bit about how that experience has influenced your view of the importance of appellate courts protecting the civil rights of all citizens.
Sure, it was an honor to work on some really interesting and important civil rights issues, from employment discrimination, things I did, or human trafficking, disability rights litigation, the whole gamut. Certainly the courts must fully protect the rights of minorities of all types in their work. I also believe, from enforcing those laws, that the courts can't go beyond what's in a constitution or in a statute either. Every time you enforce a right beyond what the text allows for, you're taking away either the political rights of the other branches of government to shape the laws how they think they should be shaped, or you're, So I think I certainly understand the importance of upholding those rights to their fullest extent. I also understand that not all instances of discrimination are protected by the Constitution nor by statutes, and that's why we've had statutes passed like the Americans with Disabilities Act. People didn't come into court and say, this should be unconstitutional, but there's a political process for that, and that was passed, and now it's enforced. And I think that's been a good addition to the law. But judges have to understand the distinction between who can add to those things, who can take away from them, and certainly understand their role in the process.
Mr. Brody.
Good to see you again, Matt.
Hello.
From the first time we met, I think I said I was impressed with your background and your education and your experiences, and I still remain impressed with that. I also understand you had your own family commission to go through last night in preparation for today, so I hope we at least are semi to the degree of what your family put you through. I noted in your introduction, in your material that you provided, you mentioned several times, the limited role of the judiciary, saying what the law is and not what the law should be, that justices need to provide a critical check on the power of the court. And so I was wondering if by saying that, I was wondering if you could expound on that just a little bit more, and whether you thought at the state level, because most of your work has been at the federal most recently, if you felt that there were some issues at the state level that you wanted to comment upon. But more importantly, with regard to, in your experiences, whether at the state or at the federal level, where you personally have had a challenge with being able to discharge your responsibilities because of, you had a disagreement with it personally, but you had a responsibility as a U.S. attorney, for example. Could you give us an example around that?
Well, let me start with the latter question, I guess. If you look at the third example of what I listed as my most significant litigation experience, the Civil Rights Division was charged with enforcing or defending the constitutionality of contracting preferences in certain federal statutes. My personal views didn't necessarily comport with the statutes in all respect, perhaps in the areas of not being narrowly tailored as I would have done it, or things like that. I certainly believe we should remedy discrimination wherever we find it, but there are different ways of doing that. And so I didn't necessarily agree with all of what the statute said, but it was our duty to defend it, and we did defend it, and we were successful in defending the constitutionality of that program. In terms of your first question, I do believe it's the role of a judge to say what the law is. The judiciary can be tempted to exceed this role and begin to make law when they believe the legislature has inadequately performed its role, or when they're faced with a case involving bad facts where their sense of justice thinks that a certain result would be the most just, but it may not necessarily comport with what the statute says or what the Constitution says. When the legislative or executive branches exceed their power, there is certainly a check in the judicial branch, and they must perform their duty in checking the other branches. But the main check on the judiciary is the self-restraint of the judges you select. And I like Winston Churchill. He has a lot of good quotes. And from my time in the legislative branches, it's not a pretty process how laws get made. There are a lot of compromises that go in. They don't always write statutes the way you would want them to. They don't always tell you how to interpret the law. But Churchill said, you know, democracy is the worst form of government, except for all the other ones that have been tried. And I think justices have to remember that, even if they get frustrated with the other branches of government from time to time.
Mrs. Renbaugh, do you have a question?
Mr. Dummermuth, thank you, and thanks for coming all the way to Storm Lake to visit with me. Just quickly, I guess, if you could, it looks to me like you're very solid as far as the intellectual part of the job and the writing of opinions and study and analysis of the law. But, you know, I'm learning how big a part of the justice's position is about outreach, which is only going to be more of the job, I think, and administration. If you could just spend a second talking about your strengths or what you could bring to the court in that way.
Sure. One aspect of the job as U.S. Attorney, or maybe up to half of my time, was spent in dealing either with the public through press conferences or with law enforcement agencies, resolving disputes, making sure everybody was working towards the same goals, making sure resources were aligned, priorities were aligned. I spent a lot of my time going into middle schools across the district, warning kids about internet predators, how to be safe online. And as much as I loved the law and doing the legal work that we had, and it was fascinating and challenging, I also loved the other part of the job, which was working with all sorts of different people, from giving presentations to middle schoolers to resolving federal and local law enforcement disputes. And so I would enjoy that mix. That it's a greater challenge, but I like the administrative work as well in that.
Mr. Cook, one quick question. We're running behind.
Yes, I understand, Justice Wiggins. Thank you. Sir, I want to ask you about your judicial philosophy briefly. You mentioned Postville, and of course you were involved in the high-profile prosecution of one of my clients, Shalom Rabashkin. The immigration charges were dismissed, and the financial case is on appeal. Share with us your view of the appellate court in our society.
Well, first of all, the appellate decision made by trial courts. There's a lot of discretion left with the trial courts and how evidence comes in. There's a lot of things an appellate court can't see from the courtroom or from their perspective in writing. The inappropriate circumstances and appropriate ways they need to defer to the trial courts, especially as to fact gathering. In terms of how the appellate courts function, I believe they certainly must ensure a fair trial, the processes for defendants or other litigants in the district court, and as to the laws, where their primary job is to make sure that the law was interpreted correctly and applied to the facts that were gathered in the trial court.
Mr. Dummermuth, thank you very much for your presentation, and we wish you the best of luck.
Thank you.
Thanks.